Hi, I'm JP Diener. I'm a litigation attorney with the law firm of Beresford Booth here in Washington. I want to talk a little bit about litigation and expectations that clients should have when they come in and decide that they want to go to court to enforce their rights under the law. We do have rights given to us by law or by contract, and the way to enforce those rights, if someone is violating them in some way, if they breached a contract or they're trying to take away your property rights, the way to do that is through litigation. You go to court and you ask a court, either a judge or a jury, to decide who is in the right. Are your rights being infringed by this other party? Are they being violated or not? And that is litigation. That's what I do, is that I help represent people who get into those problems and want to have their rights enforced under contract or law, or I defend people who are being sued for uh, for allegedly infringing on those rights. But litigation is not an easy process. It's a lengthy process. It takes time. You cannot just show up and go to court and say your side of it and it's over in a matter of days. It's not how it works. It's how it works on TV oftentimes. Been some great courtroom television shows that depict it that way. But typically it takes months and sometimes over a year to get from initiation of the litigation process all the way through trial, where you're finally having your voice heard in that trial. So it's lengthy. It takes time. It's not something that you just walk right into and get an answer. And you have to be prepared for that when you go into litigation. You have to understand that this is not something that's going to end overnight unless you and the other side reach an agreement, a settlement to resolve everything. But you're certainly not going to get in front of a judge right away. It's going to take time. Litigation is by its nature risky. There's no guarantees going into litigation. No matter how good your case is, no matter how much evidence you think you have that the other side is in the wrong or that you are in the right, um, it's going to take uh, a lot of effort. It's going to take time, and you never know how it's going to come out. You have to understand that in litigation, you put the outcome, the resolution of your case in the hands of somebody else, somebody totally unrelated to you, to your business, to the other side. It's going to be decided by an individual judge, or it's going to be decided by a jury, either a 6 person or a 12 person jury. Judges and juries, no matter how well intentioned, no matter who they are and what their background is, they may not always agree with you. They're all human. They're all fallible. They all have their own uh, individual biases that you have no idea what they may be. So you are taking a risk when you go into litigation. You again are putting the resolution of your problem, of your conflict, in the hands of somebody else to decide. You hire a good attorney to try to find a way to tell your story to that judge or jury and to apply the law to the facts of your case in a way that makes it look the best possible way for you. But no matter how good your attorney is, no matter how good your evidence is, there are no guarantees. And I have seen cases over the course of my career, and I know most attorneys will tell you the same thing. You've seen cases where you thought for sure one side, one argument was better, and it didn't work out for them, either on their own case or on the other side's case. You thought they had a really strong case, and it didn't work out. You just never know. And you can be in this business for a very, very long time, and you can go through a lot of different cases, and you can never 100% predict the outcome of these cases. So you got to understand that there's risk going in, and you got to be willing to take that risk. This is why so many cases resolve through the agreement of the parties. both sides realize that they have a lot to lose, it's better to sit down and work things out. And you're going to have opportunities through the course of litigation to reach those types of agreements. And oftentimes you will, but sometimes you can't reach that agreement, and you do have to leave things in the hands of the judge or the jury. Even if you win your case, even if you take it all the way to a judge or jury's decision, and they agree with you, they say yes, you're right, the other side is wrong, you win. Even in that instance, you may not get your attorney's fees paid by the other side. I've had a lot of clients who have come in and said, well, I want to do this, and if I win, the other side will pay my attorney's fees, right? Not usually. Unless there is a contract. If you're suing on a contract and that contract has a attorney fee provision that says if you have to sue on this contract, whoever wins gets their attorney's fees paid by the other side. In that instance, then yes, you will. If you don't have a contract like that, then you have to rely on a specific statute. And if you're not suing under a specific statute that has an attorney's fees provision, you are not going to get your attorney's fees, even if you win. And in Washington, particularly, very few statutes include attorney's fees provisions. So it can be very difficult to get your attorney's fees in some types of litigation. You need to be clear about that with your attorney. You need to understand that going in. Is this a case where I may get my attorney's fees paid by the other side if I win? Similarly, you need to understand if there's risk of having to pay the other side's attorney fees if they win. So this is a big consideration, and it's not the same across the board. It's not the same in every single case. Different types of litigation give different types of opportunities for attorney's fees, and most just don't. The last thing I want you to keep in mind when you go into litigation is that the trial or the judge's decision may not be the end, and you may get a decision that you don't like. As I said before, you may not always agree, and the jury may not always agree with you, or the judge may not always agree with you. That doesn't have to be the end of it all the time. There is an appeals process in state court. So if you get a decision that you don't like, you may have an opportunity to appeal, and that appeal goes up to what's called the Washington Court of Appeals. The Court of Appeals provides a panel of 3 judges to look at your case and decide whether or not it was decided correctly by the judge or by the jury. Appeals are always uphill battles, always. If you're appealing something that's already been decided by a judge or a jury, you're going to have to work pretty hard to overcome that and prove to this appellate court, this panel of appellate judges, that in fact the jury or the judge got it wrong. And you can't just appeal because you disagree. You can't just say, well, I don't like the outcome, let's appeal. Appeals are based on very specific things. You have to be able to show a distinct error of law. The judge misapplied the law. The judge gave an instruction to the jury that was plainly wrong and misstated the law. That type of a thing can get you an appeal. Otherwise, you have to show a complete disregard for the facts that were established during the case, or some procedural, like evidentiary error that occurred during the case. So you have to have a specific set of circumstances in order to appeal. It's not just, I don't like this, let's appeal. You have to look at it with an appellate attorney who knows this stuff to understand, okay, do you have a basis to appeal? Can you actually do this? Um, Judge opinions are more likely to be overturned than jury opinions. The Court of Appeals will give a lot of deference to juries. So if you have a jury trial, you are taking the risk that it's going to be harder to appeal unless you've got a very substantial procedural error, like an evidentiary error, or again, if the judge instructed the jury about something incorrectly. So jury decisions harder to appeal than judge decisions, harder to successfully appeal, I should say. Uh, and so appeals are a process, again, that just like the underlying litigation, just like when you went to trial, it takes time. You go through, you have to submit a brief. The other side gets time to submit a brief, but you're confined entirely to what occurred during the trial. you cannot bring in any outside evidence. So everything that happened during the trial can be considered. But if you didn't raise a particular fact, if you did not argue a particular law at trial, if you didn't introduce a particular piece of evidence at trial, the Court of Appeals is not going to consider it. You can't be like, you know what? We should have given them this map, or we should have introduced these pictures. It's too late. You can't do it at that point. So you're confined to what you did at trial. And so the appeals process is very rigid as compared to the initial litigation period. You're really confined to what you can talk about and what you can argue and what you can use. But if you have a clear error of law, if you have facts that were introduced that are very obviously not supportive of the outcome of that trial, then you have that opportunity to appeal. And the appeal very well could be in your favor. If you appeal, you could go back and have another trial, or the Court of Appeals could just say, no, actually, it should have been the other way. You should have won. They should have lost. We're doing that here. And that's great. Your last line of defense is the Supreme Court. So if the Court of Appeals gets it wrong, even more narrow set of issues will allow you to appeal to the Supreme Court. Supreme Court gets to choose which cases they take. They take very, very few. So if you're really counting on a review by the Supreme Court, you're going to probably be disappointed. It's probably not going to go that far. But the litigation process is long. The litigation process is risky, but it is how in this country we enforce our rights under contracts and under statute. We enforce our property rights, and we solve disputes and conflicts with other individuals. And it can be very effective, but you have to understand some of these things going into the process. And it's a difficult process. It helps a lot to have an attorney who really knows what they are doing. At Beresford Booth, we do know what we're doing. We have an amazing litigation team. We have developed over the course of several years some very experienced, very strong litigation attorneys. We can help you. We can advise you. We can point you in the right direction. So I urge you to reach out to us if you have a conflict, if you have a dispute that you think needs to be resolved by a court. We're happy to help. Thank you.